and prevarication by the employers. They sought to defer the implementation date by insisting that it could not be introduced anywhere if there was no agreement everywhere. In fairness, that has since been overruled by the Minister. We are now 5 weeks from implementation date. There are very few agreements for implementation recorded. Local managers seem paralysed by the instructions and demands of senior managers. Failure to agree will merely lead to accumulated hours due to staff. It's time managers got off their pedestals of principle and down to real negotiations. For our part, we have insisted we want working hours reduced in practice from the 1st of June 2008. The reduced hours are not acceptable in extended meal breaks, but must provide some real time off for rest and relaxation. Flexibility is a key ingredient, and it may be that implementation arrangements will vary from ward to ward and service to service. The reduced working week should reflect the needs of our members. Ward managers have a key role to play in reorganising the reduced nursing hours available. HSE cutbacks cannot be used to undermine nurse entitlements. The proposed new Nurses and Midwives Act is appalling in its structure and principles and details. The draft heads of the bill seeks to correct a problem that never existed. It is a fact that the regulation of nurses by a majority nurse-led board has never been criticised or drawn any negative attention or comment, unlike the Law Society, the Bar Council, the Medical Council, and so on. The bill seeks to reduce representation from psychiatric nursing by 75% and ID by 66.33%. And this disproportionate approach is completely unacceptable. And the bill seeks to provide for the holding of fitness practice hearings in public. The publication of allegations will create a reputation and stigma from which an innocent but accused nurse could never recover. And the bill seeks to provide for the maintenance of competence, which is a reasonable aspiration, but it does not provide for any role or support or facilitation by the HSE or other employers, unlike the Medical Practitioners Act. Indeed, colleagues, there are so many deficits in this draft that one can only hope that the next draft will be substantially revised and will take on board the concerns expressed in over 100 submissions submitted to the Department of Health and Children. Colleagues, tomorrow our National Chairman will present a detailed analysis of the position relating to the compensation scheme to the Minister. While I am not intending to duplicate his presentation, I do want to refer briefly to the following. The P&A have campaigned extensively over the last 15 years to resolve this issue. While progress has been made in relation to salary, sick leave and pensions, we have been put through the hoops in relation to our claim for compensation for pain and suffering. We have been in and out of the LRC, the Labour Court and Special Task Force. We have debated the issue with several ministers and experienced the broken promises of the last two. On January 22nd, a scheme was put in place, but its terms are so anemic, its omissions so glaring, and its failures in breach of everything from the Labour Court recommendations to ministerial commitments so offensive that it has merely served to highlight our sense of injustice and betrayal. Our patience is exhausted. Next week, we will commence our campaign of action by imposing inter alia an overtime ban and a ban on all assisted admissions, or cooperate with same. If that doesn't work, more action will follow. The P&A, joined by SIPTU, are determined this matter will be resolved now. We are not waiting any longer. We are committed, whatever it takes, to ensuring that injured nurses can access reasonable compensation without the trauma of a High Court case. That psychological trauma, as recommended by the Task Force on Labour Court, is included. That historical cases, that is, nurses injured some years ago, and those cases who have been listed before the courts, are resolved as recommended by the Labour Court. And that our three colleagues stabbed in Artane 15 years ago are finally compensated for that horrendous assault. Colleagues, we cannot and we will not let them down. Thank you.